Good afternoon, everyone. My name is Isaiah Green, and first of all, I'm just excited to be here today. I serve as our Assistant Deputy Director and Central California Regional Advisor for the Office of the Small Business Advocate, and our mission is to support California dreamers to start, scale, and succeed as small business owners, employees, and drivers of our economy. And so I'm just really excited. I'm excited today to moderate the first webinar episode in the partnership with our California Chamber of Commerce, our California Chamber of Small Business Policy Council, and the first of our 12 webinar series that will focus on the importance of labor and employment laws. And honestly, our goal today is to provide key information to help employers stay compliant with California's labor and employment laws while hopefully avoiding costly mistakes. And really to ensure that all Californians have help for their small businesses and stay compliant with this complex system of labor laws that we all may know about. And so today we will discuss the topic of new employment laws for 2025 with a few of our experts here, and you will get to learn and know a little bit more about them as we switch slides here. Thank you, Bianca. And so without further ado, I would like to welcome my dynamic leader, Director Tara Lynn Gray, who is the Director of the Office of the Small Business Advocate. Thank you for being here today. Director, take it away.
Awesome. Hello. Thank you, Isaiah. I am Dr. Tara Lynn Gray, Director of California's Office of the Small Business Advocate, also known as CalOSBA. And we are so excited to partner in this incredible webinar series. As Isaiah mentioned earlier, we really support the folks in California that have a special dream of growing a business and doing something for their community. So we bring quality resources and information to small businesses and entrepreneurs to help them grow and thrive. You will experience one such training today on employment law. And we are excited to be teaming up with California Chamber of Commerce and CalChamber Business Policy Council to bring small business owners free and easy to understand webinars on important labor and employment topics. We think this is important because we know that small businesses drive employment across the state in their communities, providing 2/3 net new jobs and almost 50% of all private sector jobs. So the information that we are going to provide in this series is crucial to the success, viability, and resiliency of all California businesses, really those that are big and those that are small. So we are kicking off this series with a look at what has changed in employment laws for 2025, including changes in recruiting and hiring, minimum wage increases, and what that means for exempt employees, new leaves of absence policies, and poster and pamphlet updates. So I want to thank you for joining us in this effort to strengthen your business, which in turn will bolster your local community and our beautiful state as a whole. So we know that 99% of all businesses here in California are small businesses. So we take our hat off to you for your contribution to the fifth largest economy in the world. So it's clear, and we like to say at OSBA, that supporting small strengthens us all. So without further ado, please join me in welcoming President and CEO of the California Chamber of Commerce, Jennifer Barrera.
Well, thank you so much, Director Gray and Isaiah and the entire Office of Small Business Advocate for partnering with us on such an incredible opportunity to educate our small businesses in California on some of the complex wage and hour laws, labor and employment laws that we have. As a part of our mission at CalChamber, we strive to provide resources and tools and services to employers throughout California on how to navigate these complex laws, because we know that a lot of these employers, especially small businesses, are wearing multiple hats as they're running their businesses, and they don't always have the ability to keep updated on some of the changes in the law that you just mentioned, Director Gray, or some of the updates that may have happened. And so we try to take kind of that challenge out of the process with our experts, and you're going to hear from one of our best experts in just a moment on these topics. But we really want to take that burden off of them so that they can get back to doing what they do best, which is running their small business. We are so hopeful that this series of webinars that we're able to put together with your partnership will really benefit all of you, the small businesses of California, because we could not agree with you more, Director Gray, that the small businesses are truly the backbone of California's economy, and we are so pleased and honored to do everything we can to help support them succeed and thrive in California. So with that said, again, thank you for your partnership, and it is my absolute pleasure to introduce CalChamber's General Counsel of Labor and Employment, Bianca Syed.
Thank you so much, Director Gray, President Barrera. I'm so excited to be here. I echo everything the both of you have just said, and truly it is a privilege and honor to be here and to be a part of this mission and to help small businesses. So I am just thrilled and excited and really ready to dig into the content for today's seminar, or webinar rather. And before that, of course, because I am an attorney, I have to do my due diligence in giving a few disclaimers. So just a reminder that nothing in this presentation should be relied upon as legal advice. You may have specific questions that arise. You'll want to consult with a qualified attorney. As we know, also, California law evolves very rapidly. So we just want to keep in mind that the contents that we're covering today are current as of the date of the presentation, but again, things will evolve rapidly, and you may even hear me refer to things to be on the lookout for on the horizon as we move forward into 2025. And then lastly, just we ask that the presentation not be duplicated, recorded, or distributed without the consent from CalChamber or CalOSBA. So Director Gray did a great job of setting the stage in terms of what we're going to talk about. So you have this agenda here. We're going to start off with the recruiting and hiring. We're going to talk about minimum wage increases. This is always something that is top of mind for employers, because we have to make sure we're paying our employees properly and paying the appropriate rates. But that also has an impact for our exempt employees. We're going to talk about what is the difference, what does it mean for us as employers, whether we have hourly employees or our exempt employees. We're going to see what's new in the space of leaves of absence. There were some new changes around the protected leaves that we see in California, as well as some wage replacement benefits. So we're going to talk about what's the difference between the two. Those can be very confusing, especially for those of our smaller employers. So I'm going to try to get some things straightened out for you on that front. And then we will round it out with our poster and pamphlet updates. Every year we have several updates that we need to make sure that we have for our posters and pamphlets. These have to be posted, physically displayed in a conspicuous location in the workplace. And so it's important that we make sure that we have all of those required notices and pamphlets. So we're going to talk about what those look like for 2025. All right, so let's kick it off with the recruiting and hiring space. There were really two main changes that we saw in the hiring space. And this first one has to do with driver's licenses and hiring. Now, to set the stage a little bit, when we're talking about hiring employees, it's always important that when we're recruiting, we have our advertising copy. We're never targeting a specific group of individuals or looking to exclude a particular group of individuals based on their protected status. So that's always been the case. And this is not adding to a protected status per se. However, this new law, which was SB 1100, has sort of that flavor, if you will, around what we can and can't do when it comes to our job posting and our recruiting efforts. So essentially what it does is it puts this restriction on employers from including a statement in materials that an applicant must have a driver's license unless the employer can satisfy two conditions. So in other words, we can't have this blanket requirement that for a job posting, for example, that you must have a driver's license unless we can show these two things. So first, as an employer, you need to reasonably expect that driving is going to be one of the job functions for that position. So again, if you know, for example, it's just a clerical position, there's no need for driving, right? That's not a situation where that would be a job function. However, if there is periodic, needing to travel for work to drop items off or things like that, that could fall under that category. Now, the second requirement to this is that you also have to reasonably believe that satisfying that job function by using some alternative form of transportation would not be comparable in terms of its travel time or the cost to you as the employer. So when we're talking about alternative forms of transportation, that could be a ride-hailing service, taxi, carpooling, bicycling, or walking. So in other words, if it would be comparable in time or cost for somebody to engage in those alternative methods, then you wouldn't be meeting these requirements, right? So all that to say is in the recruiting and hiring space over the years, we have seen a lot of changes and restrictions around what, things that you need to do, things you cannot include. So this is just, again, one of those things it's good to be aware of as you're engaging in your recruiting practices throughout the year, that if you have that driver's license requirement, you can meet both of these bullets here on this slide. All right, now the next law that impacted, it's in the category of recruiting and hiring, but it's not specific to our employees. This is the Freelance Worker Protection Act, and this actually is going to apply for our freelance workers and the contracts that we might be entering into with them. So for any contract that is entered into or renewed on or after January 1 of this year, 2025, we need to make sure that we have certain requirements in place. So first, let's talk about who is a freelance worker. So it is specifically defined under the labor code. It's a person or organization of no more than one person hired to provide professional services. So that definition of professional services, there's a list of individuals under that labor code section. And we're talking about photographers, graphic designers, travel agents, freelance writers, not at all an exhaustive list, but just to give you some examples. So if you're hiring this freelance worker in exchange for $250 or more, whether that's alone or aggregated during the previous 120 days, then we need to have a contract in place. Now, there are some exceptions as far as who would not be considered a hiring party. So the U.S. government, the state of California, or any subdivision thereof, a foreign government, or if it's you're hiring services for the personal benefit of yourself, your family member, or your homestead. So now, if you're falling under this Freelance Worker Protection Act, you meet that $250 value, and you need to have it in writing. What else do we need to have? There are several requirements that the law requires to be in place. So a name and mailing address of each party, the itemized list of services that are being provided, what's the date of payment, how is the payment date going to be determined, and then how is that freelance worker going to report those services rendered for purposes, right? How will they be sending an invoice? What's the method that they're going to communicate that completion? So some other things to know about this law, we have to have that date specified in the contract for payment. If it's not specified, then payment must be made no later than 30 days after the completion of services. And then this law does prohibit any sort of discrimination or retaliation against a freelance worker for asserting their rights. So what does this mean? If a freelance worker is asking, for example, for that contract from you as the hiring party, you cannot retaliate against them in any way and, no longer engage with them or no longer need their services, right? If you've already come to some agreement, that would be a form of retaliation under this law. This Freelance Worker Protection Act does have a private right of action that can be brought by the freelance worker or a public prosecutor. So that wraps up the highlights, if you will, for what was new in the hiring and recruiting space. And now we're going to talk about those minimum wage increases. And as I mentioned, what is the impact for exempt employees? Because minimum wage isn't simply about our non-exempt employees or our hourly employees. So to set the stage again for this section, let's talk about what is the difference between a non-exempt employee versus an exempt employee. In California, we're always going to start off with the presumption that our employees are non-exempt, or in other words, hourly. This means they would be paid their minimum wage. They need to be paid overtime if they're working anything over 8 hours in a day, and anything over 40 hours in a week, getting double time if they're working over 12 hours in a day. So we have those overtime requirements. You also have certain meal and rest break requirements. Again, we're not going to dig into the details on that today. There will be plenty more to come on just meal and rest breaks alone. But there are a lot of specific requirements that we have to meet with our non-exempt employees. So with our exempt employees, to contrast, they're not clocking in. We're not paying them for the time that they're working. We're paying them really for their overall, the duties that they are handling and the job that they're performing. So we're not just simply paying them by the hour. So generally this is going to be key personnel, people who have management, decision-making responsibilities. That tends to be who we're looking at with our exempt employees. Now we do have, there is a test, if you will, a two-part test. Again, this is sort of the general requirements. And this is when we're talking about what is also referred to as our white collar exemptions, which includes our executive, administrative, and professional exemptions. So we need to look at two things. First, if we're asking ourselves the question, let's say we're hiring an employee and we need to determine, this employee, we maybe don't want them as an hourly employee, and we're asking ourselves, could we properly classify them as an exempt employee? So first we have to analyze their duties. What are their job duties? Now, each exemption has specific requirements, but in general, they need to be primarily engaged in what is considered exempt duties for that particular exemption. So that means that more than half of their time, they're engaged in exempt duties that are, above and beyond doing something that maybe an hourly employee would be doing. They're customarily and regularly exercising their independent judgment. That's the language that we see a lot through the wage orders. In addition to their duties, so we look at what are they performing, their skills, what are their skills applying for that job that are being applied. What is the minimum salary? And this is where the minimum wage comes in, because it's generally tied to that statewide minimum wage. Again, we'll get to this in a moment. Now, this is, again, a very vanilla, general, sort of very basic overview of how the exempt rules tend to work. But as I mentioned, there is that wage order that lays out the specific requirements for the various exemptions. So hopefully you're familiar with your wage order. We have wage orders 1 through 17 based on your industry. And so you're going to want to refer to your applicable wage order for the specifics on the exemption requirements. So now that we've talked about sort of the difference between our non-exempt, exempt, again, barely scratching the surface there. But what does it have to do with our California minimum wage? So we know that our California minimum wage increases every year on January 1st. This year was no different. We are now at $16.50 per hour for employers of all sizes. So we no longer are in the place where we have a small employer rate and a large employer rate. We've been out of that for a few years now. So we now just have this straight rate across the board for $16.50. Now, that said, we also have probably around 40 local minimum wage ordinances for various cities and counties throughout the state that have higher minimum wage rates than this $16.50 per hour. And as of last year in 2024, beginning in April of 2024, we now have fast food restaurant employee minimum wage. And we also have certain healthcare facility employers that have separate minimum wage requirements that took effect in October of 2024. Those are ranging from $18 to $23 per hour, depending on the type of healthcare facility. Again, probably not largely for our audience today, so I'm not focusing on that, but I like to mention it because that can certainly impact competition in terms of how competitive you are, right? If there are the ability for these employees to get these higher rates in different industries. All right, so again, taking it back, what is the California minimum wage impact on an exempt employee, and why should we still care about it even if we have an employee who's not hourly? And so going back to those general tests that we talked about, the second one was that salary requirement. And when we are looking at the salary requirement, our exempt employees need to be paid no less than 2 times the state minimum wage for that full-time work. So for 2025, what this means is applying that $16.50 a rate, we need to make sure that our annual salary for our exempt employees is no less than $68,640 for that minimum threshold requirement. So even if our only employees are exempt, we still have to pay attention to the hourly minimum wage rate as it increases year after year, because we need to make sure that their salary is keeping up with those increases. Now, just a reminder too, again, that salary component is only one of the requirements that we need to look at when we're assessing whether or not an employee is properly classified. In other words, you can't just simply say, I'm going to pay this employee $68,640 for the year and call it a day, and we'll just call them exempt and we don't have to pay them overtime. We don't have to worry about these other requirements because I'm paying them that much. No, remember, we have to also look at the duties. All right. Now, with local minimum wage ordinance, as I mentioned, there are a lot here. So on this slide, again, these are all the current list. This list has grown, of course, over the years. And those that are underlined in that orange color have January 1 increases. So they increased the same time as the state. There are several that you'll see that are in the white that are not underlined. Those have July 1 increases. So they increase on a different schedule. Now, the key with local minimum wage ordinances is we're not looking at where am I, the employer, located. These are going to be based where the employee is conducting the work. So let's say, for example, you're an employer, you're located in Sacramento, and you have remote employees in the Bay Area. Maybe you have one in El Cerrito, maybe you have another one in Oakland, and they work fully remotely from their home. Well, they're working within the geographic boundaries of those locations. Therefore, they're going to be falling under these local minimum wage ordinances, and they will need to be paid that higher rate. So something to keep in mind, these local minimum wage ordinances, like the statewide minimum wage ordinances, do have the poster requirement. So in addition to the state poster, you would also be providing them and having posted in the workplace any of these local posters as well. And before moving on to this next slide, the other good news that I will mention about the local minimum wage is, although these rates are higher than the statewide minimum wage, the good news here is that they do not impact that exempt salary requirement that we discussed earlier. That's only going to be based on the statewide minimum wage. All right, now another update that we see year after year is this IRS mileage reimbursement rate. So again, why are we concerned with the IRS mileage reimbursement rate? Well, Labor Code Section 2802 requires employers to fully reimburse our employees for all necessary expenses that are incurred in the scope of the employment. This can, of course, include the use of a personal vehicle. So the California Division of Labor Standards Enforcement, who are enforcing many of these rules, they have stated that using the IRS mileage reimbursement rate will generally satisfy this obligation to reimburse for business-related vehicle expenses, absent any evidence to the contrary, meaning an employee could still submit their actual costs to you, and that, in which case you would reimburse for that. But generally speaking, this is going to satisfy your requirement. So what that means for 2025, that IRS mileage reimbursement rate is now 70 cents per mile. This is a 3-cent increase that we saw from the 67 cents per mile of 2024. Now, keep in mind that when you're talking about that mileage reimbursement rate, so let's say you have an employee going from work site A to work site B in the middle of the day to, let's say, pick up some mail or pick up a package for you, and then they're coming back to work site A, right? You're going to track all of that mileage for that pickup, and that's separate and apart from any travel time that they would be working, they're traveling for work purposes, and that's outside of their regular commute, because we don't pay employees for their regular commute, but for travel time during, for those work purposes, that is going to be, they're on the clock, so to speak, and that's separate from this mileage reimbursement rate. All right, so we've, again, barely scratching the surface on just some minimum wage and wage and hour topics. There's a lot in this area, and it continues to evolve. But why it's so important is these wage and hour requirements, and as we'll see as we continue throughout the series, through future webinars, these wage and hour requirements are highly technical. They are often subject to unintentional errors by employers. Of course, if you are, again, wearing several hats and you're doing payroll and you're, managing a team and just running your business, marketing strategy, all of these different hats that you're wearing, you can see how it can be very easy to make mistakes in this area, because of just, there are so many minefields. So, the Private Attorneys General Act is something that has allowed employees to bring claims for various wage and hour violations on behalf of not only themselves, but aggrieved employees. What makes these claims unique is that it also includes civil penalties, attorney's fees, and costs on top of any of the underlying damages. So the underlying damages might be, failure to pay overtime. Whatever those wages owed, those are the underlying damages. But on top of that, you then add on penalties and the attorney's fees and costs related to that the employee spent, right, in terms of getting the claim resolved to begin with. So very costly. But we saw some changes under two bills that were signed into law July 1st of last year, AB 2288 and SB 92. One of the significant changes is that this reform does allow employers who have taken all reasonable steps to be in compliance with various wage and hour provisions, or whatever has been identified in what is referred to as a PAGA notice. That's the first step, essentially, for somebody to initiate a PAGA claim. They have the ability to have their penalties capped. They can either have them capped at 15%, no more than 15%, so 15 cents out of what would normally be $1, for completely proactive compliance, meaning we've never received a PAGA notice, but we want to do everything we can to make sure that we are following all of the rules. We're going to engage in, taking all reasonable steps here, as referred to on the slide, can include periodic payroll audits, lawful written policies, training our supervisors, taking corrective actions with our supervisors if something comes to our attention. So that can be a massive, make a massive impact for somebody who does encounter a claim. And even if you've received a notice and you then are prospectively looking forward, right? Within 60 days, you decide you're going to take these reasonable steps, there's still a savings to where you could have those penalties capped at no more than 30%. So something I just like to mention again, it'll trickle in as we discuss other topics, but again, it's just it was new, a mid-year change that we saw last year, and I think it's a great resource for employers to be aware of when it comes to compliance. All right, so that wraps up our wage and hour, and now we're going to talk about some of those new leaves of absence policies that I had mentioned. So this first leave change that we saw was around crime victims leave. And crime victims leave has initially started off as focusing on victims of domestic violence, sexual assault, and stalking, and provided, employees the ability to take time off in certain circumstances related to being a victim of those circumstances. We recently then saw some expansion around this where it was just to a more general crime victims leave, and it was broadened in terms of who is considered a victim. What was done this year is that the crime victims leave has moved from the Labor Code to the Fair Employment and Housing Act, or FEHA, as it's sometimes referred to. And so what that means is it is now enforced by the Civil Rights Department, or the CRD, as opposed to the DLSE, because again, the DLSE, they oversee those labor code requirements. And so it's essentially going to be moving agencies in terms of who's going to be enforcing it. Now, this law also moved jury duty leave and witness leave from the Labor Code to the Fair Employment and Housing Act. And in general, what it does is it expands upon, again, what is going to qualify for the leave and essentially who can take it. Now, we're not going to go into the weeds too much on this law because a lot of this is based on employer size. So the thing to know is that for employers of all sizes, that means you have only one employee. You have to provide time off for a victim to appear in court to comply with a subpoena or some other court order as a witness in any judicial proceeding. Again, that's nothing new. For these purposes, a victim is somebody defined as a person against whom a crime has been committed. Another piece and component that's been in place, again, not new, is that employers of all sizes must also provide reasonable accommodation for safety. So let's say you do have an employee who is a victim of stalking and they might need to transfer work sites. There could be different situations here. That's something, again, also not new. Where we saw a lot of the changes is around this component of the law that applies to some of our larger employers with 25 or more employees, where they need to provide time off for a whole host of additional purposes. And for these situations, the definition of victim is large, it's broadened. And so it's revised to mean an individual against whom a qualifying act of violence is committed. And again, that qualifying act of violence is a broad definition. So something to be aware of, again, but we're not getting into the nitty-gritty on those details today, but we did see that expansion. It's just really important to know the agency, of course, now is going to change. All right, so I mentioned the paid family leave benefits. We talked about the fact that there were some leave changes as well as some changes to wage replacement benefits. So let's just talk about paid family leave benefits to start, again, just to sort of set the stage on what it is that we're talking about. So paid family leave, and I like to think of it as sort of, a cousin or some sort of relative to state disability insurance, or SDI. Both of these are wage replacement benefits that are administered by the Employment Development Department, or the EDD. And for PFL specifically, provides these wage replacement benefits for workers who are taking time off in certain situations. So if they are caring for a seriously ill family member, And as you can see, that's a very broad definition: parent, spouse, child, grandparent, grandchild, sibling, parent-in-law, or a registered domestic partner. If they are taking time off to bond with a new child, or if they are participating in a qualifying event because of a family member's military deployment. Now, the name can be a bit confusing because it has the word leave in it. So I just want to highlight that if an employee is taking time off for any of these reasons, there are two things that we always have to ask ourselves is, first, is there a qualifying protected leave that would allow the employee the time off, right? Meaning that they're protected, they're guaranteed that time. We can't penalize them in any way for taking that time. Now, even if they do have some protected time available, and again, we'll talk about what that could potentially mean, or how that would arise, there's this separate issue because it's not paid time. So if an employee, let's say, does have the ability to take 2 weeks off, let's say to care for a seriously ill family member, because let's say they are eligible for CFRA leave, the California Family Rights Act leave, which is going to apply to an employer who has 5 or more employees. And let's say they meet the eligibility requirements, because there are some minimum requirements there, then that is addressing the question of the protected time. But that's the employer's not on the hook to pay their wages during that time. It's unpaid time. Protected, yes, job protected, but unpaid. So then the question is, how can an employee recoup some of those wages? And that's where the paid family leave wage replacement comes in. And I like to emphasize again that wage replacement benefit, because the name can be confusing for not just employers, but also for employees. So what changed around the paid family leave wage replacements this year? So previously, an employer could require an employee who's taking time away, they're eligible for this PFL wage replacement benefit. An employer could require an employee to take up to 2 weeks of their earned and unused vacation, essentially, completely prior to that employee receiving PFL wage replacement benefits in that 12-month period for which they're eligible. So they basically could be required to exhaust their own earned and unused vacation before they could tap into those PFL wage replacement benefits. Well, this law, AB 2123, what that does is it eliminates the employer's ability to have that requirement in place, meaning employees do not need to exhaust their earned and unused vacation prior to receiving those PFL wage replacement benefits. Now, whether they want to supplement, because as we'll talk about in a moment, PFL wage replacement benefits are not 100% of your wages. So there is the ability for an employee to supplement to get themselves up to 100% of their wages during that time, if they have that earned and unused vacation available. So along the same lines, it's still staying on the topic of SDI and PFL. Remember, these are 2 different wage replacement programs that we're talking about. We talked about how somebody could be eligible under the PFL wage replacement program. Now, what about SDI? So that state disability insurance is going to come into effect if we're talking about an employee who is out, is unable to work due to their own illness or injury that's non-work related, or if they are out of work because they are disabled by pregnancy or aren't taking pregnancy disability leave, which covers employers with 5 or more employees. So if you have 5 or more employees and you have a pregnant employee, PDL is something that you also have to be aware of. So those would be the situations where somebody would take SDI. So whether it's SDI or PFL, as I mentioned, these are partial wage replacement programs. So previously, it was that the rate was between 60 to 70% of the wages that an employee earned in the highest quarter of their base period. And now, so SB 951, this was signed back in 2021. but had a later implementation date. And so as of this year, that replacement rate is now between 70 to 90% of their wages. So in other words, employees are able to get a higher percentage of their wages through these programs, meaning they still will not be up to 100. They will still have the ability to supplement their wages through earned and unused vacation or potentially sick leave, again, depending on the circumstances that they have to get themselves up to 100%. So these tables have all been updated. Again, if you are, the other thing I'll mention with these programs, there's nothing that you have to actively do as an employer other than provide the pamphlets, because as we'll talk about, these are two important pamphlets that you do need to provide to your employees upon hire or anytime there's discussion about a leave or they're inquiring. That's going to get them the information that they need so that they can go to EDD. This is all employee initiated. What you might need to do is likely provide coordinating information with the EDD, responding to information, verifying in terms of, again, if they're tapping into their vacation or whatnot during, so that there can be that coordinated effort. So you will have some participation, but again, it's not costing you anything. You're just simply providing whatever information may come through for EDD and directing the employee to their pamphlet and the website to apply. All right, so then that brings us to poster and pamphlet updates, which I think SDI and PFL, again, is a great segue into that because those are two pamphlets. Now, I'll go ahead and start at the bottom with pamphlets since we're on the topic. We did see one last minute mandatory update for pamphlets this year, and that was the paid family leave pamphlet. So you do want to make sure that you have that that particular revision date there listed with the date 1/25. We oftentimes have the question, I have old pamphlets and I didn't use them all. Can I just get rid of the old ones first? Unfortunately not. You want to make sure that you're providing the most current information and those required pamphlets. So now let's see what were the posters that are the mandatory updates. So California minimum wage, again, shouldn't be a surprise as we discussed that minimum wage is going to, we see it increase every year. We also saw an update to the California law prohibits workplace discrimination and harassment. There was an update to the DWC notice to employees injuries caused by work. There was some small language in there that got added for employees to be aware of with respect to their rights around an attorney and recouping attorney's fees and costs. The family care and medical leave and pregnancy disability leave notice had some changes to it, as well as the whistleblowers are protected notice. This is now an official notice. We've always had a model notice, but there was some legislation that basically now we know that this is the specific notice that you need to have. So there were very minor changes, but again, you want to make sure that you have that correct notice in place. I mentioned those wage orders, again, hopefully not new to you if you have employees, because you do need to be aware of what is the wage order applicable to your industry. If not, or you might be subject to more than one, again, depending on the nature of your business. Those, in addition to that California minimum wage poster, does have to be conspicuously displayed in the workplace where employees can have access to it to review it. So don't forget about that. And of course, if you have work sites or employees working in any local ordinance areas, you want to make sure that you have those postings as well. We didn't touch on it in today's program, but aside from local minimum wage ordinances, there are several other localities that have things like their own paid sick leave ordinances. Again, we didn't even scratch the surface on paid sick leave. That's a whole separate webinar in and of itself. So there are some locals that have their own paid sick leave ordinances, as well as some other employment related or local ordinances beyond minimum wage. So I like to call that out so that people are aware of. All right. And so finally, I just want to round it out with some annual reminders that hopefully you've already done some of these things, but it's a good, just a basic checklist as a starting point for, just to make sure that you're checking certain things every year at a minimum. So again, we talked about that statewide minimum wage. You want to make sure that you're staying on top of that. If you're subject to a mid-year local minimum wage rate, you're going to need to adjust that come July. So you always want to make sure that your employees are receiving whatever that minimum wage is or that minimum salary. Posting all of those updated notices like we talked about, updating those pamphlets, providing them upon hire, making sure those are the most current. Taking all reasonable steps like we talked about to take advantage of the PAGA reform and to be in compliance with that wage and hour requirements. Updating your employee handbook policies, so things like crime victims leave or as other leaves get updated, you want to make sure that your employee handbooks are updated as well. And then lastly, just staying up to date on any required training, such as harassment prevention training or any other training that you might be subject to depending on your size and industry. So just some annual reminders there. And I think I've probably talked everybody to death at this point. So I will turn it over to you, Isaiah.
Bianca, we are live and we are kicking because this information has been super, super helpful. I know we do have a few questions. And are you open to answer a few questions?
Yeah, absolutely.
Awesome, awesome. And so I do have a few questions. I'm going to throw them in the chat. That way you can see them. But I'm going to start with one. I think we're talking about paid family leave. And so one of the first questions we have here is, how will I know if an employee is eligible for paid family leave?
Yeah, that is a great question. So, and again, understandably confusing because of the name. So remember that paid family leave, as we were talking about it today, is actually not a leave of absence. So in other words, it's not a protected leave that is going to guarantee you protections to come back to your job. What paid family leave is, so let's just take an example to break it down. So you have an employee, they're missing work, they're not getting paid because they're caring for that ill family member scenario that we talked about. Now, they would be eligible to apply to the EDD to get those wage replacement benefits that we talked about, right? That's paid family leave. That is a separate issue from looking at and analyzing, are they, for example, eligible under the California Family Rights Act for protected time off under this leave, because that is one of the eligible reasons under CFRA leave, because there are protections that come along with it. But let's say they're not eligible, but an employer is still going to allow them the time off. They, from EDD's perspective, they're just going to ask the question, are you losing wages because you're doing one of these things, one of which is caring for an ill family member? Then that's where that money piece is going to come in. Again, separate though from the leave of absence itself.
Awesome. Awesome. Man, I appreciate your expertise in this. This is really good. This is really good. I have another question, Bianca, from a small business down in San Diego. Now, this one is a little lengthy, and so I'll take my time with this, but it is around family leave or just leave of absence in general. And so as a small business in San Diego County with under 25 employees, we need guidance on handling paid family leave, CFRA, California Family Rights Act, and FMLA for an employee taking pregnancy-related leave. All right. And so I think the few questions, the follow-up questions, Bianca, are if her hours drop below full time before giving birth, are we still required to provide healthcare benefits? That's one question. And then the next one is, does pregnancy disability leave count separately from CFRA or FMLA, or is it post-birth leave reduced? And so those are the two follow-up questions to that very in-depth question from a small business owner in San Diego.
Yeah, so that is a very specific question. So I'll start off by saying, so San Diego, I don't believe San Diego City does have some local ordinances. San Diego County, again, you'd want to double check. There's nothing specific around these types of leave that we're talking about, though, that would from the local perspective. So what we're looking at really is we're talking about, that pregnancy disability leave and then CFRA and FMLA leave. So, okay, so let's take, again, I don't know the employer size, but FMLA is going to apply to employers who have 50 or more employees. So that's going to apply to our larger employees. That's the family and medical leave that's at the federal level. Then we have the counterpart to that, which is the California Family Rights Act, that CFRA leave. That's going to cover employers with 5 or more employees. So there's a big difference. CFRA and FMLA years ago, both used to be 50, and then California largely expanded it and said, nope, employers with 5 or more are also going to need to provide this. So let's just start there. I'm going to set FMLA aside, and I'm just going to focus on the California piece and just make some assumptions here that maybe they're under 50, but more than 5. So again, and so PDL, that's separate from CFRA. Pregnancy disability leave also covers employers with 5 or more employees. Now, there's no minimum eligibility requirement. You can have an employee who's hired on day 1 needs to go out on PDL, and that's just fine. There's no requirement. It covers up to 17 1/3 total leave time. So in the situation where you have an employee, if let's say they're dropping below because they're working maybe part-time, they're using some of that pregnancy disability leave. The thing to know is whether it's a part-time basis or whether they're on a full-blown leave, any time that is PDL, they need to have their healthcare benefits maintained. So that employee would still have access to their healthcare benefits. I hope that answers that part of the question.
Awesome. And it looks like it was an employer with about under 25 employees.
Yes.
So that's super helpful. We have a few more questions, Bianca, Next question, can an exempt employee receive a prorated salary if they only work part-time hours?
Oh, great question. We see this one a lot, again, because you have to look at, are they meeting the job duties, and then are they getting the minimum salary? The minimum salary requirements are assuming that's for full-time work. If you are having an employee who's really only working part-time, you're probably going to want to look at that from the perspective of, are they really even meeting the job duties? If it's, if they're part-time, but you do not have the ability to simply prorate. That would not meet the minimum requirement. They have to meet that minimum salary, regardless of the number of hours that they're going to be working.
Awesome. Thank you for that, Bianca. We have another question here around minimum wage increases from one of our small businesses here in the Central Valley. Let's see. The ongoing minimum wage increases are making it difficult for small businesses, especially those of us employing students. Are there any appeal processes or exceptions available to help independent business owners stay sustainable?
Yeah, that's a good question. So the minimum wage that we talked about, again, that's really the minimum salary. Now, we talked about the wage orders, and there's also that the minimum wage notice. One of the things that is covered in the wage orders is this idea. There is a limited exception for learners, where regardless of age, they can be paid no less than 85% of the minimum wage, that's rounded to the nearest nickel, during and this is the key part, the first 160 hours of employment. And that has to be in an occupation in which they have no previous or similar related experience. So it's for a very limited time in that very limited circumstance. There are, for the local minimum wage ordinances, some of those also have a similar exception. So again, if you're subject to local, that's something you could look at, but remember, it's for a very finite period of time.
Awesome. Thank you for that. I think we have one final question here, if you're open to it, Bianca.
Yes.
Awesome. Last question for, let's see. Okay, here it is. For exempt employee classification, are there other exemptions aside from 3 white-collar exemptions that you mentioned?
Yeah, so this is a good question. Again, exemptions and exempt employees is we could do a whole day, honestly, on the topic. So those are the most common, but we also have things like, for example, the computer professional exemption. I didn't highlight that, but that one in particular has annual rates. So that one's different, where you can actually meet the pay requirements through an hourly or a monthly or an annual salary, and those rates are set by the state every year, and they do increase. The thing about the computer professional exemption is sometimes people hear that and they think, oh, so if I have like an IT desktop support person, they could meet this exemption. No, it's very specific. They have to be primarily engaged in work that is considered intellectual or creative. They're working with software design, computer systems analysis, programming, software engineering. So again, your wage order is going to give you all the rules around that, but that's just one example. We also have outside salesperson exemptions, commissioned inside salesperson exemptions. There's also a licensed physicians and surgeons. That one has an annual rate that increases. So there definitely are other exemptions out there to be aware of. And you want to make sure that whatever classification you're applying for your exempt employee, that they're meeting that through their job duties and the pay.
Awesome. Well, thank you, Bianca. I think that wraps up all of our questions. And so just with some closing remarks, I'd like to add one, Bianca, thank you so much for your expertise. Thank you so much for sharing this knowledge with us. On behalf of the California Office of Small Business Advocate, myself, Director Dr. Tara Lynn Gray, who was on earlier, Jennifer, President of California Chamber of Commerce, and of course you representing the California Chamber of Small Business Policy Council. I think this was a great start to our webinar series. I'm excited for the information, the expertise, the knowledge that is going to continue to flow down the pipeline to our employers who need it and who matter the most in this space. And so again, I just want to say thank you to all of those who are listening, to all of those who are attending and tuning in. We hope that you took something away today that you can utilize and put into practice. We look forward to the next one. Please look out for our next webinar series episode, which will take place in March. We do want to hear your thoughts, so please click on the link. We will have a link provided, a survey link. We want to hear your feedback. We want to know the information that you took away today, how practical it is, how you're using it, what other information would you like to hear about. We want to be able to engage with you. And so thank you. Continue to register for these events as we move forward. We appreciate you all for being here. We know that this information will continue to uplift all small businesses here in California. And so with that being said, Bianca, thank you so much. You did an excellent job, and I look forward to doing this again with you.
Thank you so much, Isaiah, and thank you all to everybody who attended today. Yes, I am so excited about this series, and I really want to make sure that we're getting the information that you need. And so, like Isaiah said, share your feedback and your thoughts so that we can really, curate something amazing here and get you what you need so that you can do what you do best, which is business. So
that's right.
Thank you.
Awesome. I love this partnership. I look forward to the next one, Bianca. Enjoy the day, everyone. Thanks for tuning in. Until next time.
Thank you.